Hi guys, welcome back. EEOC isn't biased against workers who have mental health impairments. In fact, one of their current strategic goals is to prevent discrimination against us. But having a mental illness can make the EEOC process more challenging whether or not our complaint is directly related to it. Because we have to deal with so many stereotypes that cast us as volatile, unreliable, and generally unworthy of our rights. We know those judgments are out there, so most of us don't disclose our mental health issues until we have to. Keeping quiet does protect us from being singled out for mistreatment because of our impairment, but it comes at a price. Without reasonable accommodation, we can flounder and make mistakes that could cost us our job. It can affect our physical and mental health because of all the extra stress of trying to manage on our own. And it feeds a sense of shame about our impairment that can damage our self-worth. So do we disclose or not? It's a catch-22, and the right answer depends on how badly we need reasonable accommodation. I've had major clinical depression since my mid-20s. Looking back, I can definitely see how having reasonable accommodation would have benefited me. But at the time, all I saw was how NASA treated people who asked for them, so I never did. Until later in my career when I had to, because of a physical disability. Now, because of my pre-existing depression, the scariest part of the whole EEOC process for me came during discovery, when NASA requested 10 years of my medical records. Not just the medical records directly related to my physical disability, but all of them. Now, by that time, they already knew that I had depression and I was seeing a therapist. Those things came out during my investigation, so they specifically requested copies of all my therapist notes from our sessions. They were fishing for anything they could twist into a legitimate, non-discriminatory reason for what they did, or into proof that I wasn't credible or I was unreasonable, or worst case, if they lost, to minimize the damages they had to pay by showing that I was already damaged before the discrimination. I didn't want to give NASA that chance, so I gathered the medical records that I thought were relevant, and my attorney objected to the rest as overly broad and cumbersome and unnecessarily intrusive. Now, there's some case law that supports those arguments, and I'll link to these in the description. In Reed v. Baxter Healthcare, the court states medical records that are beyond what's directly relevant to our claims may be considered intrusive. In EEOC v. Boeing, the court stresses the need for discovery requests to be narrowly tailored to the issues of our case. Doe v. Oberweis Dairy addresses the legal requirement that our employer's need for information be balanced with our privacy concerns. And in McGinnis v. the U.S. Postal Service, the court says any medical inquiries have to be relevant. They can't be overly broad. NASA's response to our objection was to file a motion to compel, but before our AJ would act on it, he asked the attorneys to get together and try to work something out. NASA's attorney wouldn't budge. She said that they needed everything they asked for. But while they were talking about it, my attorney noticed something. NASA's initial request for discovery had been filed a day late. So my attorney said, "No valid request, and we're not giving you anything." Nothing. NASA went to the AJ and requested an extension after the fact, but he said no. And here's some case law that supports that decision. My request for reasonable accommodation was because of a physical disability that I'd had just about 3 years at the time we were doing discovery. So asking for 10 years worth of my medical records was obvious overreach. But what if your complaint is related to a mental health impairment? What then? First, know that therapy notes have real potential to wreck your case. All an employer really needs to prevail is one good instance of us being irrational, reactive, or dramatic that they can spin in the ways that I talked about earlier. Most of us who are in therapy have our moments, and our therapist notes capture them all, so we don't want to hand those over without a fight. My therapist knew that, and he also knew that he didn't have to hand over his notes. He directed me to a Supreme Court case that said so. Jaffe v. Redmond was decided by the Supreme Court in 1996. That established that private communications between a patient and therapist are privileged, and we can't be compelled to disclose them. And since then, Hout v. the University of Maryland has addressed therapy notes specifically in the context of a Title IX sexual harassment allegation. In that case, the court found therapy notes aren't discoverable. Throughout my whole EEOC process, I was really worried that if EEOC found out about my depression, they'd write off my complaints as just paranoia or hysterics, like so many people do. But that didn't happen. In fact, my pre-existing depression was part of the rationale that my AJ gave for awarding me the maximum non-pecuniary damages. He said the severe and pervasive humiliation that I suffered because NASA refused to reasonably accommodate me made my depression worse. Even though NASA knew I was depressed coming out of my investigation, they still didn't do anything to protect me from further harm. My AJ, and later the EEOC Office of Federal Operations, held him accountable for that. In the end, it was sweet irony that the mental illness I had been so afraid to disclose throughout my process actually ended up working in my favor. Because the law treats mental health impairments like any other impairment, not like a character flaw or a personal choice. EEOC sent that message to NASA, and I hope some of what I've shared today will help you send that same message to your employer, loud and clear. See you guys in the next one. Then take care and hang in.